Today on BenchBriefs, we're looking at a landmark decision from the Supreme Court of Canada that explores the tricky balance of power between federal and provincial governments. The case is Canadian Western Bank v. Alberta, decided in 2007, and it deals with who has the authority to regulate banking in Canada. A question that might sound dry, but actually has big implications for how provinces can protect consumers without stepping on federal toes. Here's what happened. Canadian Western Bank, or CWB, is a federally regulated bank operating in Alberta. Like all banks regulated by the federal government, it operates under federal laws designed to ensure consistency and stability in the banking sector across Canada. But Alberta passed a new law that imposed certain regulatory requirements on financial institutions within the province, including banks like CWB. The purpose: to protect consumers and regulate financial activities more closely within Alberta's borders. Sounds reasonable, right? But CWB wasn't on board. They challenged the Alberta legislation, arguing that the province had no business regulating banks because that's the exclusive domain of the federal government under the Constitution Act of 1867. The bank said the Alberta law was unconstitutional because it intruded on federal jurisdiction over banking and therefore was ultra vires, beyond the province's power. So the big legal question before the Supreme Court was this: did Alberta's law unlawfully encroach on federal powers, or was it a legitimate exercise of provincial authority? More specifically, the court had to decide how to interpret the division of powers between the federal government and the provinces when it comes to regulating financial institutions like banks. To answer this, the court looked at the concept of pith and substance, which means they examined the true nature or main purpose of the Alberta legislation. If the law's primary purpose was to regulate banking itself, then it would be ultra vires the province. But if the law was mainly about something else within provincial jurisdiction, like consumer protection or property and civil rights, then it could be valid even if it incidentally affected banks. The Supreme Court ultimately ruled in favor of Alberta, holding that the provincial legislation was constitutionally valid. The court found that the law was not about regulating banking per se, but about regulating certain aspects of financial services and protecting consumers within the province. Since these matters fall under provincial powers, Alberta was within its rights to enact the law. The court emphasized that federal jurisdiction over banking is broad but not absolute, and provinces can regulate in areas that relate to banking as long as they don't impair the essential core of the federal banking power. This decision is important because it clarifies that provinces have room to maneuver when it comes to regulating financial institutions operating within their borders. It confirms that federal power over banking doesn't give Ottawa a monopoly over every aspect of financial regulation. Provinces can step in to address local issues and protect consumers without being automatically overruled. In the bigger picture, Canadian Western Bank v. Alberta highlights the ongoing balancing act in Canadian constitutional law between federal uniformity and provincial autonomy. It shows that the division of powers is not always a rigid line, but sometimes a nuanced overlap where both levels of government can have roles to play. For consumers and financial institutions alike, this case means that provincial governments can enact laws that address local concerns without necessarily conflicting with federal banking laws. Thanks for listening to Bench Briefs. Be sure to join us next time for another episode where we break down key legal battles shaping Canada's legal landscape. Until then, take care.